Thank you.
Putting aside how it applies in this case, the SG's methodological approach, as I understood it, I want to make sure whether you agree or disagree with it. What I understood the Solicitor General to say is that the scores, you start with the scores, but then you have to go on, usually, maybe always, to consider all the other evidence. But then when you make the final evaluation, you can't forget about the scores as part of the overall analysis.
That is, I agree 100% with that, and the district court did nothing of the sort.
Right, on that latter part, I know you disagree, but on the methodology, anything you disagree with the Solicitor General on?
My memory is even worse.
I'll push it a little further. I mean, it's possible that the place you do disagree is, I think that the Solicitor General had an exception for scores that were, this is his in the brief, the, many 90 scores. And he said, the scores can be such that you wouldn't have to. I think he had that exception, that caveat.
I agree with that. I mean, you can take an example, for example, of somebody, I'm not sure if I've exactly got his hypo right, but let's say 4 90s and 171.
Right.
The court would certainly hear expert testimony on that. There may very well be expert testimony, maybe even agreement, that the 71 is in fact the result of malingering, or that it is a statistical outlier and taking into account other evidence relevant to intellectual functioning should be disregarded. But I think a a state court that said, come on, the guy has 4 90s and 171, and I've heard expert testimony on both sides, and I find on the basis of that the defendant has not satisfied his burden of proving by a preponderance. What we have here are 4 or 5
on that hypothetical,
if I may just finish my sentence.
Yes, sure.
What we have here are 2 experts who said 4 of the 5 scores are within the range of intellectual disability. The district court itself specifically found that, and so we're not in that hypothetical range, but I agree with the Solicitor General.